5 words that have ended more innocent people's freedom than almost any other phrase in law enforcement history. We just want to talk. And the moment you believe them, the moment you sit down, or step outside, or pick up that phone, or open that door, the conversation that was described as casual becomes the most consequential exchange of your life. No Miranda warning, no attorney, no recording you control. Just you, an officer who has been trained in interrogation science, and a conversation that is going to be used against you in ways you will not fully understand until you are sitting across from a prosecutor 6 months later wondering what you said that started all of this. The most dangerous place you can be in a criminal investigation is in a room with law enforcement believing it is not an interrogation. Subscribe to this channel right now, because the video after this one covers what happens when the talk they wanted leads directly to a formal interview request, and that escalation has its own legal architecture, its own pressure points, and its own exact words that this channel covers in depth. Before the words, you need to understand what "we just want to talk" actually means in a law enforcement context, because the phrase has a specific investigative function that has nothing to do with the casual conversation it sounds like. When law enforcement says they want to talk, one of 3 things is true. They believe you have information relevant to an investigation of someone else, and they want to develop that information, in which case anything you say can and will be used to build a case, potentially against you as well as against the target. They believe you are a suspect, and they want to develop evidence through a non-custodial conversation that avoids the Miranda protections that attach to formal custodial interrogation, in which case the casual framing is specifically designed to lower your guard before the questioning begins. Or they have already developed significant evidence against you, and they want to give you an opportunity to explain yourself, in which case your explanation, however truthful and however innocent seeming, will be placed alongside their evidence and used to evaluate your credibility, your knowledge, and your culpability. In all 3 scenarios, talking is the mechanism by which evidence is created, developed, or tested. The conversation is not social. It is investigative. The information you provide does not stay in the room. It goes into a report, a recording, a memo, or an agent's notes that become part of an evidentiary record that you will not see again until a defense attorney puts it in front of you. The phrase "we just want to talk" is designed to make the most consequential conversation of a potential criminal proceeding feel like the least consequential thing in the world. Here is the piece of this conversation that most legal commentary skips over entirely, and it is the piece that explains why the "we just want to talk" request produces compliance not from guilty people trying to manage their exposure, but from innocent people who genuinely believe that truth is their best protection. Innocent people talk because they are innocent. The logic seems unassailable. If you have done nothing wrong, you have nothing to hide, and a conversation with law enforcement is an opportunity to clear up a misunderstanding, provide context, and demonstrate your cooperation with a system you believe will recognize your innocence if you simply explain it clearly enough. That logic is understandable. It is also the logic that has produced wrongful convictions, false confession cases, and destroyed lives across decades of documented American criminal justice history. In Saul Kassan's research on police interrogation and false confessions, among the most cited in the field, the data consistently shows that innocent people are more likely to waive their Miranda rights than guilty ones, precisely because innocence produces confidence that the truth will be sufficient. Innocent people do not expect that their truthful account will be mischaracterized, that details they got slightly wrong under stress will be presented as lies, that things they said will be taken out of context and assembled into a narrative they do not recognize, or that talking to law enforcement without an attorney present is the single most reliable way to transform an innocent person's position into a prosecutable one. The truth alone does not protect you in an interrogation. The truth, filtered through the training and the agenda of the person receiving it, becomes something else. And you have no way to control what it becomes once it leaves your mouth. Here is the legal mechanism that makes the "we just want to talk" request so dangerous, and it is the one that allows law enforcement to use everything you say without the constitutional protections you might otherwise have. Miranda versus Arizona established that before a custodial interrogation, law enforcement must advise a suspect of their right to remain silent and their right to an attorney. The key word is custodial. A person in custody, under formal arrest or under circumstances where a reasonable person would not feel free to leave, is entitled to Miranda warnings before questioning. A person who is not in custody, who is speaking voluntarily, who is free to leave at any time, has not triggered Miranda's protections regardless of how incriminating the questioning becomes. The "we just want to talk" framing is frequently used specifically to conduct questioning outside the custodial environment that Miranda requires. You are not under arrest. You came voluntarily. You can leave whenever you want. And everything you say in that voluntary, non-custodial conversation is fully admissible in a criminal proceeding without any warning having been given, without any invocation of rights being required, and without your having understood at any moment that you were being questioned as a suspect. The courts have been consistent on this. In Illinois versus Perkins, the Supreme Court addressed undercover questioning and the voluntary nature of statements made outside formal custody. In Burgess versus Tompkins, the court held that a suspect who wants to invoke the right to silence must do so unambiguously. Simply remaining mostly silent for hours while occasionally answering questions was held insufficient to invoke the protection. The lesson from these decisions is stark. Voluntary participation in a "we just want to talk" conversation is a Miranda-free zone. And in a Miranda-free zone, the only thing protecting you is knowing not to walk into it in the first place. Here is where "we just want to talk" appears in practice, because the phrase arrives in 5 distinct contexts, and each context has a slightly different legal architecture and a slightly different set of exact words. The first is the knock on the door. Officers appear at your home, unannounced, and say they just want to talk. You have not been arrested. You have not been subpoenaed. They are on your doorstep with what seems like a casual request. The second is the phone call. A detective calls your number, identifies themselves, and says they are working on a matter and would love to get your perspective on a few things. The third is the approach in public. An officer approaches you in a parking lot, at your workplace, outside a building, and says they just want to ask you a few questions. The fourth is the station invitation. You receive a call or a visit asking you to come to the station voluntarily to speak with an investigator. Again, just to talk. The fifth is the scene encounter. You are present at or near a scene that is being investigated, and an officer approaches and says they just want to understand what you saw or what you were doing there. In every one of these contexts, the phrase performs the same function. It presents an investigative questioning opportunity as a social one. And in every one of these contexts, the correct response is built from the same constitutional foundation, delivered with the same calm precision, and grounded in the same legal reality. You do not have to talk. And the consequences of talking without an attorney are the same regardless of which context produced the invitation. Here is the constitutional architecture that governs every version of this moment, and it is more protective than most people realize when they are standing at their door or holding their phone or sitting in a parking lot being told this is just informal. The Fifth Amendment to the United States Constitution protects you from being compelled to be a witness against yourself. That protection does not require formal custody to apply. It does not require a Miranda warning to exist. It does not require that you be a named suspect. The Fifth Amendment protection against self-incrimination belongs to you in every context in which your words could tend to incriminate you, including a voluntary conversation on your doorstep with a detective who told you it was casual. In Chavez versus Martinez, the Supreme Court addressed the scope of Fifth Amendment protections in non-custodial contexts. In United States versus Patton, the court addressed the relationship between Miranda violations and the admissibility of evidence obtained through voluntary statements. In Griffin versus California, the court held that prosecutorial comment on a defendant's silence at trial violates the Fifth Amendment, but the protection that matters here is not the trial stage protection. It is the pre-interview protection, the right to say nothing before the conversation starts. The Sixth Amendment right to counsel attaches at the initiation of formal criminal proceedings, indictment, arraignment, formal charge. Before those proceedings begin, there is no Sixth Amendment right to a government-appointed attorney at a voluntary interview. But there is nothing that prevents you from having your own attorney present at any voluntary interview. And there is nothing that requires you to speak to law enforcement without one. Nothing. Not politeness. Not civic duty. Not the investigator's assurance that this is just informal. Nothing. Here is what most people do when "we just want to talk" arrives. And both responses produce outcomes that damage them in ways they do not see until the damage is done. The first person agrees and talks. They believe their innocence is their protection. They believe that a truthful account, delivered clearly, will demonstrate that they have nothing to do with whatever is being investigated. They do not account for the fact that memory is imperfect and that inconsistencies between their account today and what witnesses say or what records show will be characterized as lies. They do not account for the fact that details they provide about their whereabouts, their relationships, their communications will be cross-referenced against evidence the investigator already has, and that any discrepancy, however innocent, becomes a prosecutable fact. They do not account for the fact that the investigator's job is not to find the truth. It is to build a case. And a cooperative subject who talks at length is the most efficient case-building resource available. The second person refuses, but does it badly. They say, "I have nothing to say to you." They close the door without a word. They hang up the phone. They become hostile or aggressive in ways that the investigator documents, and that, in a subsequent prosecution, can be characterized as consciousness of guilt. A hostile refusal is not the same as a legally protected invocation of silence. It is a behavioral data point that an investigator will use. There is a third path, the one that closes the door on the investigation without producing anything usable, without creating a hostile encounter, and without waiving a single constitutional protection. And it begins with 3 words. So here are the exact words. And because we just want to talk arrives in 5 different contexts, there are 5 versions, each calibrated to the physical and legal specifics of that scenario. The first and most important is the door. When officers knock and say they want to talk, you are under no legal obligation to open the door beyond the crack required to confirm their identity. You do not have to invite them in. You do not have to step outside. You do not have to accept documents through the door that convert a voluntary encounter into something else. From behind a closed or barely opened door, you say, "I am not going to speak with you without my attorney present. If you have a warrant, please slide it under the door or hold it up to the window. If you do not have a warrant, I am ending this conversation. Have a good day." Then you stop. You do not ask what it is about. You do not say you will call them back. You do not express sympathy for whatever investigation they are conducting. Every word beyond the response is an invitation to continue the conversation you just declined. The door is the most powerful position you will ever have in an encounter with law enforcement. You are inside. They are outside. Nothing crosses that threshold without a warrant or your permission. Do not give permission. Do not step outside where the threshold no longer protects you. Do not let the conversation begin, because once it begins, it is almost impossible to end without producing something usable. The second context is the phone call. When a detective calls and says they want to talk, the phone creates a false sense of safety. It feels informal. It feels like you are in control because you can hang up, and it feels like talking without being present is somehow lower stakes than talking in person. It is not. A recorded phone call with a law enforcement officer is an evidentiary document. Your words on that call are admissible. Your tone, your hesitations, your corrections, your volunteered details. All of it is captured and all of it is usable. The moment you understand that the caller is law enforcement conducting an investigation, your response is, "I appreciate you reaching out. I am not going to discuss this matter without my attorney present. If you would like to contact my attorney, I am happy to provide that information. I am ending this call now." Then end the call. Do not stay on the line to be polite. Do not ask what the call is about, because the answer to that question is the beginning of the conversation you just declined. Do not say you will have your attorney call them back if you do not have an attorney yet, because that statement has just committed you to a timeline and an engagement you may not be ready for. If you do not have an attorney, the response is identical. You are not going to discuss this matter without one, and you are ending the call. The third context is the public approach. An officer who walks up to you outside, at work, in a parking lot, and says they just want to ask you a few questions. You are not under arrest. You are free to leave. And the fact that you are free to leave is the most important piece of information you have in that moment. "Officer, am I free to go?" If the answer is yes, go. If the answer is no, I am invoking my Fifth Amendment right to remain silent, and I want an attorney before any questioning. If the answer is that you are being detained, you are now in a different legal category, and the exact words for a detention apply. The fourth context is the station invitation, a call or visit asking you to come in voluntarily. Your response: "I am not going to come in or speak about this matter without my attorney present. If charges are filed, my attorney will be in contact." Do not go to a police station voluntarily without an attorney. The station is the investigator's environment. Every element of it, the room, the chairs, the positioning, the waiting, the sequence of the questioning, is designed to maximize psychological compliance. You have no advantage there that you do not have at your door or on your phone. Do not give it up. The fifth context is the scene encounter. You are present near an investigation and an officer approaches asking what you saw or what you were doing. I am not going to answer questions without my attorney present. Am I free to go? Every context. One constitutional foundation. 5 versions of the same response. Here is what happens inside a voluntary, we just want to talk conversation if you agree to have one. And understanding what the investigator brings into that room with them is what makes declining the invitation feel not like fear, but like simple logic. The investigator knows things you do not know they know. They have spoken to witnesses before they spoke to you. They have reviewed communications, records, surveillance footage, financial documents, or other evidence before the conversation begins. They know where the inconsistencies in their theory are, and they are going to ask questions designed to fill those gaps with your words, or designed to surface an inconsistency between your account and the evidence they already have that they will characterize as a lie. The investigator is trained in the READ technique or a variant of it, a structured interrogation method that includes behavior analysis, minimization, maximization, false evidence ploys, and theme development. The false evidence ploy is legal. An investigator can tell you they have evidence they do not have. They can tell you a witness identified you when no witness did. They can tell you your phone records show something they have not seen. They can tell you your associate already gave you up when no associate has spoken. All of it is legal. None of it is required to be true. And a driver who knows they are innocent, who is told that evidence already places them at the scene, who does not know that false evidence claims are a trained interrogation technique, that driver will often try to explain the evidence away rather than invoking silence. The explanation is the evidence. The room is not a conversation. It is a collection exercise. And the only defense against a collection exercise is not being in the room. The pushback when you decline a "we just want to talk" request is different from the pushback at a traffic stop, because it often comes wrapped in legitimacy, urgency, and the suggestion that declining is itself suspicious. Know every version before it arrives. If the investigator says, "This is just informal," you are not in any trouble. The informality of the framing does not change the admissibility of your words. Not in any trouble is not a legal status. Your response does not change. If the investigator says, "If you have nothing to hide, this should take 5 minutes." 5 minutes is all it takes to produce a statement that becomes the centerpiece of a prosecution. Your response does not change. I am not going to discuss this matter without my attorney present. If the investigator says, "The only people who lawyer up are the ones who did something wrong," this is a specific pressure technique designed to make the exercise of a constitutional right feel like an admission of guilt. Courts have held that invoking the right to counsel cannot be used as evidence of guilt. Your response does not change. If the investigator says, "Your cooperation now could make a big difference later," cooperation without legal representation is not a recognized mitigating factor that prosecutors are bound by. It is a statement that you did not understand your rights and spoke anyway. Your response does not change. If the investigator says, "We are going to find out the truth either way, you might as well tell us your side." Your side, told without an attorney, becomes the prosecution's most useful document. Your response does not change. If a formal subpoena or grand jury summons is later produced, that is a different legal event with different requirements, and you will need an attorney to navigate it. A voluntary interview request is not that. Declining a voluntary interview is not defying a subpoena. They are legally distinct events, and treating them as equivalent is the investigator's most effective pressure tool. Here is the piece that most drivers and most citizens worry about the most. What happens after you say no? What does declining do to the investigation? Does it make you look guilty? Does it accelerate the timeline toward charges? Does it close off options that cooperation would have left open? The honest answer, supported by what defense attorneys across the country consistently tell their clients, is this. If the evidence against you is sufficient to support charges, those charges will be filed whether you talked or not. Your cooperation did not prevent the charge. It only added a statement to the evidence package. If the evidence against you is insufficient to support charges, declining to talk protects you from providing the statement that fills the gap. You cannot talk your way out of a case that has the evidence. You can only talk your way into a case that does not. The fear that declining makes you look guilty is the investigator's most powerful tool, and it is a fear that operates on the exact same psychology as every technique covered in the previous video. Looking cooperative feels safer than looking like you have something to hide. But looking cooperative and being protected are not the same thing. And in an investigation where the question is not whether you look innocent, but whether the evidence supports a charge, the only thing that matters is what is in the record. A declined interview leaves the record thin. A cooperative interview fills it. Thin records do not support charges. Full records do. There may not be a body cam in the "we just want to talk" encounter, but there is almost always a recording. Investigators record voluntary interviews. They take notes. They write reports of the conversation. They have a second officer present who becomes a witness to what was said. And in a subsequent prosecution, the record of the voluntary conversation, however it was captured, is presented to a jury alongside the physical evidence, the witness testimony, and the investigator's characterization of your demeanor, your consistency, and your credibility. A driver who spoke voluntarily without an attorney is presented as someone who had the opportunity to tell their story and chose to tell it a certain way. A driver who declined is presented as a defendant who exercised their constitutional rights, which in a courtroom, properly argued by a competent defense attorney, is exactly what it should look like. The Fifth Amendment right to remain silent cannot be commented on by prosecutors at trial under Griffin v. California. A defendant who said nothing to investigators is not a defendant who gave the jury something damaging to sit with during deliberations. The silence is protected. The statement is not. Every word spoken in a voluntary interview that does not match the physical evidence, however innocently, becomes a credibility problem at trial. The credibility problem that never exists is the one that was never created. Do not create it. Memorize these before you close this video. When "we just want to talk" arrives at your door, I am not going to speak with you without my attorney present. If you have a warrant, please present it. If not, I am ending this conversation. Close the door. When it arrives by phone, I am not going to discuss this matter without my attorney present. I am ending this call. End the call. When an officer approaches you in public, am I free to go? If yes, go. If no, I am invoking my Fifth Amendment right to remain silent, and I want an attorney before any questioning. When a station invitation arrives, I am not going to come in or speak about this matter without my attorney present. Do not go. When approached at a scene, I am not going to answer questions without my attorney present. Am I free to go? When the pushback comes in any form, I am not going to discuss this matter without my attorney present. When formal process arrives, consult an attorney before responding to anything. The phrase "we just want to talk" is not a conversation. It is an evidence collection request. You are not required to provide the evidence. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances. If this video reached you before anyone ever stood at your door or called your number with those 5 words, it did exactly what it was built to do. Subscribe to this channel right now, because "We Just Want to Talk" is one entry point into a criminal investigation that has a dozen others, and every single one of them has a legal framework and a set of exact words that goes with it. This channel covers all of them. One scenario, one constitutional foundation, one set of words, so that when the moment arrives, you are not flattered by the casual framing, you are not fooled by the informal tone, and you are not walking into a room to have a conversation that only one person in that room understands is not a conversation at all. Subscribe. Share this with everyone you know, not just drivers. Everyone. Because "We Just Want to Talk" is not a traffic stop scenario. It is the scenario that arrives at anyone's door, on anyone's phone, in anyone's parking lot, at any moment, with no warning, framed as the most reasonable thing in the world. Make sure the people you care about know what it actually is. Make sure they know what to say. Make sure they stay protected. Stay calm. Stay protected. Stay free.